So with that, I would move on to the topic, sexual connotation in harassment and discrimination. With that, I'll proceed. This is a standard disclaimer. There are some scenarios that I'll play out during this session. It uses characters and scenarios which are fictitious. Any resemblance is regretted. It's purely coincidental, right? So with that, I'll just move forward to the scenario. So here's a scenario in an office space where there's a celebration related to someone's promotion. So here, Divya is promoted as a senior consultant in the team. Her manager, Nareen, announced this in the team meeting, and it was a celebration time. Everyone was happy, clapping, and everyone was glad that Divya got through. But someone was not really happy. Sylvia is definitely not happy. She joined along with Divya the same day, and they had comparable performance. Sylvia was even better in some cases. They both were good friends, and so good that both of them shared a lot of their personal stories. Sylvia also knew that Divya and Naren were in a personal relationship. Both were even planning on getting married very soon. So, in this scenario, Sylvia apparently feels that it's partiality and bias because she already knew that they are in a personal relationship, and Naren gave this promotion in return for the relationship. Right? It's a give and take. As the personal relationship played a bigger role in Divya's promotion than the performance of either Divya or Sylvia. Right? So in this scenario, Sylvia contacts you because you're the IC member to take help in filing a sexual harassment complaint. So what do you think of this case? I'm just going to launch a poll. It might come up in a separate window within your Zoom. Please take time to go ahead and vote for this. What do you think of this case? Is it A, sexual harassment quid pro quo, B, sexual harassment hostile work environment, C, implied sexual harassment, or D, it's not a sexual harassment case? Okay. If you want to take a look at the scenario, I will go back to the previous slide because the questions are anyways available on the poll. So we will give it another 10 seconds for people to respond. Okay. So I will close the poll, and here are the results. So we have about 61% of them mentioning this as not sexual harassment, about 17% mentioning it as quid pro quo, and 17% again on hostile work environment. And one of us feel that it's implied sexual harassment. So I just wanted to understand your views. Like, why do you feel so? Right? What is the reason you feel that it is either quid pro quo or hostile work environment or not a sexual harassment? If you want to put in some comments on the chat window, it'll really be good to share that viewpoint. Okay. For some reason, there's. I hope you're able to. Yeah. So Sandhya has mentioned it's hostile for Sylvia since Divya got promoted due to personal relationship with Nareen. Okay. That's a viewpoint. Divya did not complain. There was not. There was no unwelcome acts for her, so not sexual harassment. Okay. Thanks, Sash. Thanks, Ravanti. Okay. So yeah, this is not sexual harassment. So right, so obviously we are also looking at Sylvia approaching the IC. So from her point of view, probably that's also something that we can look at. It is not sexual harassment because it is her assumption about personal relationship, and there is no harassment as such. All right. So yeah, most of these answers are correct. So let's just quickly look at the definition of sexual harassment. So going back to Vishaka guidelines, it it clearly had the statement as well that sexual harassment includes such unwelcome sexually determined behavior. So and if you look at it, in every point in that has some form or the other, except for the physical contact and advances, which was probably a direct giveaway that it might be a sexual harassment. But in all the other points, we have sexual favors, demand or request for sexual favors, sexually colored remarks, showing pornography, and um, any conduct which is of sexual nature. So there are so many points, and everything is like it should be related to something sexual. So that's something that we need to consider. The reason why we look at Vishaka guidelines, because that forms the basis for the POSH Act of 2013. Though in the POSH Act, the initial statement of sexually determined behavior was slightly modified, but the rest of the points remain the same. And there is another section within the POSH Act, which is about the implied or explicit promise. So we need to really look at if there is an implied promise of preferential treatment in her employment. So we need to look at it not from Divya's point of view, from Sylvia's point of view, because she's the one who's coming and contacting the IC, whether she can file the sexual harassment complaint or not. So here we need to look at whether it's an implied promise or not, right? So if you look at it, we need to consider from Sylvia's point of view whether there was any implied or explicit. Definitely not explicit, because Naren did not ask about it. We need to also see if there is any implied promise of preferential treatment. So that's something that that people might have questions on. But from the look of it, because it's a consensual relationship, it's not like open offer for anyone where you will get preferential treatment. It looks like a consensual relationship, because even Sylvia knew that they're going to get married. So the implied part can also be questioned, right? So on the complaint from Sylvia, Sylvia was not harassed, or Naren did not request or approach Sylvia directly or indirectly in any form, right? Sylvia got to know about the relationship through Divya because they are close friends, and Divya did not complain. As someone pointed out here, Divya did not complain of harassment at all, and the relationship appears completely consensual based on the information that is provided in this scenario, right? So in this case, it appears to be a clear conflict of interest, which is resulting in discrimination. Definitely so, because Sylvia's performance was much better than Divya, or at least in most cases, as per the scenario. And so it is a case of discrimination uh, based on conflict of interest. You may call it as nepotism, cronyism, but definitely not sexual harassment, because that's not the case here. Right. Let's just go further. Naren's actions, we're not trying to justify saying it's not sexual harassment, but it's definitely deplorable, as it's an employment decision. In all laws, if there is a conflict of interest, Naren should ideally disclose this relationship to HR, and the reporting structure should have been changed. He should have recused himself from all the decisions. Apparently that's not something that's been done, or at least the scenario doesn't present the facts related to that. So as per the organizational code of conduct policy or conflict of interest policy, Naren should have withdrawn himself from the decision, and or he should have moved to a different team, or something of that kind should have happened. So this case must be handled by um, the organization's grievance redressal committee, and definitely not the internal committee. There should be some kind of a structure in every organization to address other kinds of grievances as well. So that's maybe the HR designee or the HR team would have some committee or structure for that. That's the team that should handle it, and not the internal committee, right? So is there any question or comments that need to be discussed, or is this point fairly clear? Okay, if there are any, you can probably put it on chat or put it on Q&A, and we'll come back to that as we go through, right? So let's understand what is not sexual harassment, right? So this is a very critical question. So not every type of action is sexual harassment. Female employee being asked to stay late to complete an overdue project, it's definitely not sexual harassment, but it can be looked at it from that point of view, that it's late and I'm a female employee, and so it is harassing. But as long as the women's safety policies, for example, the place where we are from, Bangalore, I think most part of India as well, beyond 7 o'clock, women employees should not stay in the office. But if they do, then they must be provided with cab facilities so that they can go back home. By the organization, they should provide the transport facilities. So something of that kind is there as a law. But other than that, if the women's safety policies are adhered to, this is not sexual harassment. It might not be the environment where the woman employee feels comfortable working late, but uh, the organization is responsible for providing a safe environment. But asking them to stay back and work for a business exigency to complete an overdue project, it is not actually sexual harassment, right? The next point is a male supervisor discriminating against all women in his team, like screaming, shouting, loathing, despising, giving them poor performance ratings, hikes, etc. This is also not sexual harassment. It is gender based discrimination. Definitely it's deplorable, but it's not sexual harassment, because we need to look at if there is a sexually driven act, or if the act has a sexual connotation to it. If there is nothing that's evident there, then it might be categorized as gender discrimination, but not exactly sexual harassment. Even performance related feedback or warning letters, or non warning letters for non performance or coming late, or any of those will not be considered as sexual harassment. But if there is a history to these actions, like for example, um, if someone was called for an outing or a dating or for a coffee, right, and that person declines that request, and after that they are asked to stay back late to complete projects, or they are put into a hostile work environment, like shouting and screaming, or even giving out warning letters for performance or apparent performance related reasons. If there is a history where the initial action was with a sexual connotation, but the later retaliation, as we call it, retaliation is non-sexual, then that is still considered as sexual harassment, right? So I hope this part is clear. And we saw in the definition every type of action or conduct had sexual word in it, except for the first one, right? So the physical harassment. Even in case of physical harassment, we need to verify if there is sexual connotation, or if the behavior is sexually driven. More so because we need to understand this very clearly, because that's the only statement where it doesn't say the word sexual, or directly or indirectly mention anything related to sexual. Um, Even in case of pornography, it's kind of very clear that it's a sexual, there's a sexual connotation to it. But in this case, it's not mentioned. So even in this case, a physical altercation without sexual connotation should not be considered as sexual harassment. So for this, let's also look at the case law, because it's not just the law and the rules, which is of course clear and comprehensive, but there's also a case law. In its judgment, High Court of Delhi, Shanta Kumar versus Council of Scientific and Industrial Research, CSIR, and others. Um, the case reads like this, where the complainant was working at a laboratory, and the respondent entered the laboratory due to their previous historic altercations, stopped the machine, snatched the samples from the petitioner, had thrown them out, and then had the the respondent dragged the petitioner out of the laboratory and then locked the laboratory. So there was a sexual harassment case filed, because the complainant felt that the respondent holding her hand and dragging physical contact or advance is to be considered as sexual harassment. The internal committee, with its at that point, if you look at it, the case when it was filed, the POSH law was not in place, so it was based on the Vishaka guidelines. The judgment was given, or the entire case went through based on the Vishaka guidelines book, right? The rules that were provided by that. So the complaints committee had mentioned that it is not sexual harassment, while it's something that we should have stopped, or it's deplorable, but it's not of sexual nature. Even the judgment supported that viewpoint, because not every action should be considered as sexual harassment. Plainly, all physical contact cannot be termed as sexual harassment. Only physical contact or advances which are in the nature of unwelcome sexually determined behavior would amount to sexual harassment. So that's what the judgment also felt. So from this, we can also understand that even physical contact is not considered as sexual harassment unless it is sexually motivated, or sexual connotation is there, and it's an unwelcome act with sexually determined behavior, right? So that's something that's clear even in case of physical altercation. So the question is like, how do you determine if it is really sexual harassment or not? If that particular physical act, or even the act, is sexual harassment or not? Like, for example, there may not be a sexually driven or sexually determined behavior, but someone might still feel that it is sexual harassment. So how do we determine if it is sexual harassment or not? Any comments that you can actually share in this case? How do you actually determine if it is sexual harassment or not? You can probably put it on chat and we can discuss that. Let's see the viewpoints there. Okay, it is sexual in nature, right? And as you said, it shall be based on history. Yes, history plays a role. But for example, someone feels it's sexual harassment, while the other they don't. They just said like, no, that's not what I meant, and that's not the intention. So Rajesh says if the person was physically or mentally harassed, that made the affected uncomfortable in office space, yes, but also considering the previous understanding, it should also be a sexual, some kind of sexual connotation should be there. Unwelcome to the aggrieved, no matter what the IC member feels at the time of filing the harassment complaint. Yes, it doesn't matter what the IC member feels, and it should be unwelcome to the aggrieved. The behavior has to be understood from the victim's point of view. Very correct. I think similar to what Ruchira had mentioned. So it should be from the victim's point of view. Anything that makes the women not comfortable. If any higher manager sends wrong message on WhatsApp or other source and trying to be very personal, it comes on harassment. Yes, it would sound like harassment, because if it's a personal message and it's not appropriate, then it could be. History may not always be relevant. The act should be in perspective of aggrieved, not the intent of the respondent. Absolutely, that's exactly what we're going to discuss. Let's just move forward. Thanks a lot for your comments. So intent versus impact, right? Exactly what some of you had mentioned in your chat. It's exactly that. The impact on the complainant is more important than the intent. So as the picture depicts, the the weightage is much more on the impact on the person who's impacted by this act. And I might have no intention of hurting someone or sexually harassing, but if that person feels sexually harassed, then that person has a right to feel it as sexual harassment and shall be deemed that way, right? So let's also look at this. But there is also a viewpoint that the other person did not intend. So for example, let's also look at this. There can be different perspectives in this. One, even the greeting standards vary, and we all know that. For example, in India, we have till a few years back saying namaste is the most popular greeting, and that's something that irrespective of the gender, we used to greet that way. But of late, shaking hands is also fine, right? It's absolutely fine. It's understood as a professional way of greeting. But in some countries, even that is not allowed. Say for example, if you go to Middle East, if a man tries to offer his hands to shake, but if the other person is not initiating it, then it can be considered as an inappropriate behavior, because the culture there is that you're not supposed to shake hands with the other gender, and you should know, you should restrain. It's the women. The women should actually raise their hands and shake first, so that, or offer their hand, then the man can actually offer his hand. So that's the way it's looked at in the culture. Some of the rules are also, it's not advisable to shake hands, a salute or a wave of the hand. That's accepted as a normal greeting. If you go west, several European countries, or North American countries, you will find that hugging is very much normal part of their greeting, right? So even strangers, the first time when they are introduced, they would probably give a hug. If you go to European, you would find that a peck in the cheeks is like absolutely normal. If in case you reverse that, you do that here in India, or you do this there, and it's kind of very weird. So we need to understand that perspectives change based on where you are, the background from which you come from, the level of education that you have, the level of exposure that you have. Everything would actually determine whether you find this as normal or not. So what's perfectly normal for you might not be normal for the other person who's in the context, right? So we need to understand from both sides, and more so from the side where they feel they are harassed. So there is a clear way to actually judge that. So it's called reasonable person standard, and that's something that should be used to determine whether it's sexual harassment or not. So previously it was reasonable person standard, and it was usually considered with reasonable person as the male, whether the act that they did was considered as sexual harassment by another male of a similar nature with a similar education or background or exposure. But now, after the recent judgment, or not so recent, but after judgment by Justice Muralidhar, the case law is also provided on the right. It is more appropriate to look at it from the woman's point of view, because any act or behavior is considered to be sexually harassing if the reasonable woman, when put in that situation, would deem it to be so. So what it means is that the reasonable woman is someone who's been of the same kind of background in that culture. Say if you are picking someone from South India, then you need to look at someone who's kind of with the same kind of educational background or exposure. If that person would have felt this act, the act of the respondent has sexual harassment, then that is considered as sexual harassment. If everyone in that culture feel that it is not actually sexual harassment, would have felt that this is absolutely normal and it's not sexual harassment, like shaking hands, then still the person who feels sexual harassment might want that to be addressed. So it could be the severity of the action that is taken by the IC can also be varied based on this the reasonable person standard, but still it should be considered from a reasonable woman standard whether it's sexual harassment or not. And then based on that, your judgments should also be, or your how you take action on that should also be modified. But it should be based on the reasonable women standard. The reason why it changed to women, not reasonable man or reasonable person standard, is because it gives us so much more opportunities to be sensitive to the victim. Because if it's the judgment by Justice Murli, there are clearly states, there's a statement like a male supervisor might believe, for example, that it's legitimate for females, for him to tell a female subordinate about commenting about their body or figure, while a female subordinate might feel it really uncomfortable, and that comment could be perceived as offensive, right? So it's very important to understand being sensitive to the other side. It should be looked at from the point of view of the victim, whether that comment is considered as sexual harassment or not. So this is a very clear definition with which we can judge whether the harassment is sexual harassment or is it another form. That's something that you can easily judge. It need not be just about the victim's point of view, but it's also about reasonable women standard, and which I see in its collective wisdom can actually understand, right? Shravanti has mentioned education has nothing to do with cultural mindset. Yes, absolutely. It doesn't have. So those are just the criteria that we can consider to see whether it should be considered as sexual harassment or not. But it need not be the criteria. And if the IC feels that even cultural mindset is to be different, as I said, it's a combination of several factors, not just one. So I know it might be wrong to just say that cultural alone should not be looked at, because even the geography need not be considered as the only criteria. Because when I go to go to Middle East and meet, it's possible that they might offer willingly straight away, but some of them may not. So it's a very complex thing. You need to consider a lot of factors and then identify whether that's the sexual harassment or not, right? So I'll just move on to the next one. So here we need to understand the purpose of the POSH Act. The reason why we need to actually look at that is to see whether, why not handle these cases as sexual harassment? What's going to be the big difference? Because it's anyways come as a complaint to us. So let's just do it because the POSH policy is strong, and it gives a very transparent way or a very solid way of resolving those issues. So here are the points why we should not look at using the IC internal committee to handle cases which are not related to sexual harassment. One, it is for a specific purpose of preventing sexual harassment at workplace. So POSH IC is empowered to conduct inquiries with the powers equivalent to that of a civil court, like summoning and evidence and calling someone for witness, everything. These are powers for a specific purpose. It's not available to every other grievance redressal committee unless the organization feels that it must provide something of that kind. But the Act provides it only for a specific purpose of sexual harassment, right? So using these powers to investigate or recommend punishments for any other purpose, right, that should be avoided at all times, because as you know, it's got powers of a civil court, but there can always be an appeal, and it may be contested in court or an appellate tribunal, because tribunal can also rule over and say that, okay, this should not have been handled by the IC, and so we nullify the whole thing. And so that's not a comfortable situation to be in. So you should be very careful to handle only the ones for which the Act is purposed for, right? So also you need to look at it as a distraction for internal committee, right? POSH Act is for a specific purpose again. And if IC spends valuable time on other cases which are not related to sexual harassment, anyone would actually use this as the mode to come in to file a complaint, and it would IC would be spending a lot of time on this and would not achieve its purpose. This time can be used on other important sexual harassment related cases to prevent that from happening next time. The inquiries, because the whole process itself is a lot more complex and the time requirements are huge. Meetings and town halls related to this, brown bag small group discussions, because not you will not get all the points from meetings and town halls. You can also look at other ways of eliminating discrimination, even gender-based discrimination, to through these town halls, apart from just fixing sexual harassment related cases. But if you use the time for the inquiry process of every other case, then the critical part of addressing sexual harassment at workplace would not be done. Awareness sessions, because that's something that's clearly missing in several organizations, and this is something that IC can actually go ahead and address if the time is available for them, right? And also, you need to consider that the other part where you go through the grievance redressal, that's an internal HR designee or something. It's a lot more faster and simpler process. The process is also not so cumbersome, but here you need to involve also an external member, the time of the external member who's got a bigger role to play in terms of preventing sexual harassment in not just one organization, in many. So that's also something that we need to consider in terms of distraction of IC, apart from the cost effect related to that, right? So effect on the employee and the employer. So if you look at Naren, Divya, and Sylvia's case, right? If you look at it as a conflict of interest, the emotions that we get from that case is different. But if you look at it as sexual harassment, it's actually emotionally overwhelming, both for the complainant, respondent, and even to Divya, who's actually part of the triangular story. So even for her, it's going to be emotionally overwhelming. It's not something that's desirable, because the word sexual harassment is looked at differently from a conflict of interest. While both acts are completely deplorable, I would only want to put that sexual harassment is even more deplorable than conflict of interest, but both are equally deplorable. It's like the first among the equal types, right? So, in terms of compliance requirements, the sexual harassment investigations would be actually a lot more strict in terms of compliance requirements, while the general organizational grievance redressal mechanism can be a lot more lighter on the organization. It can be avoided if it's not actually sexual harassment. Even in the previous example, like sexual harassment complaint versus a grievance redressal, when it's not sexual harassment, it's going to be even more emotionally overwhelming. And same here, where if it is not sexual harassment, they're wasting your resources on inquiry procedures, time requirements, reporting requirements, meeting confidentiality, and all that. While everything would have some amount of importance, but sexual harassment cases have a lot more. So investing all those resources on a non-sexual harassment complaint would be considered as not a desirable situation. So, what should be done in such a case where someone contacts you to help you write the complaint or filing a complaint as you're the IC? Then, first thing that you must probably try and do is understand and clarify the case with the complainant, but whether your understanding is complete, whether it is in line with what their thought process is, so that you're clear before suggesting anything to them. And then you can explain the purpose of POSH law and see if they still feel it as a sexual harassment. Because uh, at this stage, the complaint is not filed. They are just contacting the IC to take support. In that scenario, you still have a chance to explain the POSH law and explain the process of sexual harassment inquiry and how it is, and ask them if they still feel it as a sexual harassment. Also, some organizations would have a policy where about accepting complaints, whether you accept any complaint and then investigate, or whether you see whether it's sexual harassment or not and then accept the complaint. So it might be dependent on your organizational policy. We've seen both examples. So just take a look at the policy and see how about accepting these complaints when you feel it's not sexual harassment. And based on that, you provide the grievance redressal options that are available in the organization, right? Like you can contact this HR person who addresses this, or this is the process in which you need to actually go about. So you should do all of that. If they still feel it's sexual harassment, because we also said that it's the impact that's very important, then you must accept the complaint and leave it to the rest of the internal committee as well to go through in depth, rather than just one person's view on it. You should let the entire internal committee also look at it, or the committee that's formed for the inquiry, they should look at it and they should decide on it. But never even give the feeling to the aggrieved women that they are discouraged from filing the sexual harassment complaint, because they have the right to do so. They should be understanding the purpose of the law and the reason why they are trying to complain, and if it is really sexual harassment or not. That understanding should come up, rather than a feeling where they feel that they are being discouraged from filing a complaint, and they might even question, like, then why even have an IC if they're not going to investigate it? So it should be done in a very careful way. As an IC, I'm sure you would know how to put it, but it's very important to make them feel that at that time when they feel aggrieved, you must provide all the support that they need, but also make them realize that this is not really sexual harassment. And if you feel so, give the reasons and tell them that this is a better option and faster option, maybe more beneficial option for all of the parties involved, right? So that is the viewpoint. So I have some comments here. Can IC have discretion to take up the sexual matter? Can company SH policy give that discretionary power as perspective of aggrieved to be taken up? Sometimes they can't put harassment into words. So while this should be considered like a suo motu kind of an action, which is something that is not possible because of the way the complaint is, the law is enacted. It's a civil case, and there is principles of natural justice, and you need to have the person file the complaint so that you can actually go forward with the inquiry. It is not something that you can take as a suo motu action and take up the complaint and inquire or take action on. So that is not possible. The aggrieved woman should file the complaint. If you feel that some incident has happened, and as an IC you can support them in filing the complaint, you can explain it to them, you can tell them how to proceed in terms of this situation, but still the choice is with the aggrieved women. They should come up and submit the complaint. But if you feel that there is a widespread activity which can be considered as sexual harassment, you must not take it as a single case, but more of an organizational initiative to build awareness against that, so that people can come out. If they feel harassed, they can come out and complain. But you cannot take suo motu action and file a case or take up a sexual harassment case from your side. That's something that's not possible, right? So hope that answered. So I hope this point on what should be done in case they seek your help in terms of filing a complaint, that I hope it's clear. Let's look at what if they've already filed the complaint, right? They did not contact you. They just filed the complaint even as a written letter. On some organizations, they have an email box where they can actually send the complaint, or uh, whatever form. So you can actually look into your organizational policy on sexual harassment about accepting complaints. If there is a mention about accepting only sexual harassment related complaints, there's still grounds for you to actually direct the complaint straight away, even without taking up for investigation in to the grievance redressal committee. You can forward that complaint so that you don't have to have the sexual harassment internal committee deal with that complaint. But if there is no mention of such an acceptance, or if you feel that there's still some doubt whether it is really sexual harassment or not, and that can come up only through inquiry, then you may still accept and take it forward to the next set, where you follow the principles of natural justice. So I'm sure all of you should already know about principles of natural justice. You just, in short, it should not be like a one-sided ex parte kind of a action. Both parties should be consulted. Both parties, their viewpoints should be heard. They should be given option to cross-examine each other, and then you decide whether it's sexual harassment or not. In this case, you must also remember that this is a civil case, and it's decided based on the preponderance of probability, and need not be beyond any doubt. If you look at all the other scenarios in criminal kind of cases, you need to actually look at the proof and evidence to make the person who judges on the case to feel beyond any doubt that this person has committed the crime. But in this case, and rightly so, it's based on the probability whether it could have happened or not. So there are different levels of it. Probably in another session we can cover in detail about the preponderance of probability. First you eliminate all the impossible events, and then you go ahead with, from the ones which are the ones that we find that they are possible to happen, then you're looking at whether they are probable to have happened. Then you judge based on that. So it's based on probability. So even if you feel after some rounds of inquiries or initial statements that you receive from both sides, if you feel that by probability from all the evidences that are disclosed there, you can also decide that it is not a case of sexual harassment, and you can forward it to the grievance redressal committee, right? So once the IC feels convinced that it is not a sexual harassment, you can forward the complaint to grievance redressal mechanism in your organization. So we need to remember this point very clearly while classifying it as either sexual harassment or not. Any incorrect classification can be detrimental because, as I mentioned, it can also be contested in court or appellate tribunal, because some of the UGC has its own tribunal option. So either it's the court or the tribunal, but it can be contested and can be overruled. So you need to be careful before you classify, because some cases you're refusing to go further on the inquiry by just based on certain evidences. You need to just be very careful. But if you feel that it is by probability that it is not really a case of sexual harassment, I think it's better to actually move it to the grievance redressal committee or grievance redressal mechanism in the organization, because that's going to get a speedy resolution, and it's also going to get make it a lot more easier for everyone involved, while still getting to the problem, or the fixing the problem for the aggrieved woman, right? In case of Sylvia, I think she definitely deserves to contest that, but not as sexual harassment, but definitely the grievance redressal mechanism would probably take appropriate action, right? So Moto, however, clarifies the perspective as well, Mike. Okay, thank you. Beyond reasonable doubt. Yeah, sorry. I think that should be corrected there. So, in summary, I think we've reached towards the end of it. I know I've kind of dealt with a point where asking IC not to take up certain type of complaints, but I just wanted to be very clear that we should not discourage taking up sexual harassment complaints. It is only the complaints which are not sexual harassment that should be directed to the other mechanisms. It should still be handled, but it should be directed by the mechanism that's there in the organization for that specific purpose. All complaints that are filed must be taken up and investigated subject to your organizational sexual harassment policy. Principles of natural justice must be followed during the inquiry, where both parties are heard, both parties get the option to present their side of the case, and if the case is identified as not sexual harassment, please avoid recommending action, because if someone finds that, because during the inquiry nobody is going to have legal support or aid to actually support them, because as per the law as well they are supposed to defend themselves on their own. But definitely if they feel that their complaint is not accepted, or the reverse of it happens where it is dismissed without, or if the action is taken, whoever is the victim of that action, not the victim of the harassment but the victim of that action, would definitely find a way to fight back, because it's something that they've lost as a phase, or something that they felt that they were right. And at that point, they would definitely try to see if there is any way to actually redeem that. So at that point, they might go for the next level of appeal. So it is very important to avoid recommending action on cases where it's not sexual harassment, because they would be a victim, they would be wounded, and they would definitely go forward. So just make sure as an IC, you judge or you provide or recommend actions only on sexual harassment cases. Everything else, even though you feel that it's wrong, please forward it to the grievance redressal process, because that's the right team to actually look into it, and we need to actually let them decide on that. So now that brings an end to the presentation from my side. I'm willing to take up questions for another 5 minutes, and we can actually look at it. Should we guide them if the case they are referring comes under POSH or employee grievances? Yes, absolutely. We should guide them. And if the complaint is already received or in any form, you should also look at forwarding it to the right team, because not everyone in the organization, in fact, some of the organizations, even big ones, they don't even know who's the IC. So I really suspect if a grievance redressal, which is not even a law as a process in India, they would have something that's publicized in the notice boards and all that. So it is important for the IC to know who those people are and probably even forward it to them rather than just guiding them. But yes, we should definitely guide them and even help them file that complaint if that is helping. Any other questions? There is one question: is mediation a possibility? So reconciliation. So yes, it is a possibility if the complaint has come up, and during the inquiry process, you also find that one party requesting for reconciliation, and if both parties agree, and if particularly the party is aggrieved woman comes up with that request, so you can actually look at reconciliation and settle that if in case that's going to give a resolution, but it's within the POSH Act. But uh, at that point, you should not have determined it as not sexual harassment, because then the whole reconciliation process can also be questioned. But in case of reconciliation, there is no appeal in the next level, because both parties agree at the end of it. So I don't think that question would come up, but definitely reconciliation is possible during the inquiry process. If both parties agree, that's something that you can also look at. But if you identify it as not sexual harassment, I think that's something that still should be handled by the grievance redressal, because just to stay clear of the further appeals and all that. But if it's not yet identified and still inquiry is progressing, both parties agree, I think we need to actually go ahead with that. Okay, Mali, before case coming to IC, the case has been already filed, a complaint to local police station. What must IC do? So it is even more a reason for IC to also constitute a group to inquire into that, go through the case, if the aggrieved woman had actually indicated it through a written complaint to the IC. But if the agreed woman did not file that complaint to the IC, but they just went straight to the police station, then without a complaint, you cannot go ahead and investigate. But if they file it with IC, it's a bigger reason for you to actually go and find the root cause and take action from the organization side, because otherwise it could also be looked at as organization has not taken the required action to protect the safety of women employees. So it's very important for IC to do it. But if the complaint comes to you, if the complaint has not come, but you get to hear about a sexual harassment case filed in the police, you can uh, reach out to the aggrieved woman and understand, and if they want to file a complaint even through this law, so then you can actually take it up and move forward with that, right? Okay. Shravanti, starting the session with case study holds the interest. Thanks, Shravanti. Thanks for the feedback. And then Rajesh, while the case is under process or inquiry, are both employee need to have been given break from office. Okay, so interim measures, it's a separate topic of its own, but let's just briefly discuss that. It's something that's possible that the aggrieved women might feel that there could be some retaliation or might create a hostile work environment for themselves, or things might not go well. There are several options, including paid leave, right? That is also an option. While the other person could also be given the paid leave. But remember this: there's been cases where, without the first part, principles of natural justice, if you take action like suspending or giving paid leave to the other person without hearing the other person, then there can be a problem. We had that even in a suicide case in Gurgaon a couple of years back, where an employee of a senior or a popular organization committed suicide while he was suspended after the complaint was received. He was never given a chance. So that situation should not happen. So you should still provide options of interim measures after the principles of natural justice, the initial round of giving the other person an opportunity to explain their side. Those things must still be followed, but you have the option of giving the interim measure if in case the aggrieved woman comes up with that request. So there's a question on the panel in some so in this case, the police will guide her to file the complaint with IC. I really doubt if the police will guide, not in all cases, but police has its own law. I think it's 354, one of this ABCD, something like that. So there is a law where, according to which sexual harassment is an act. It's a law by itself, and they would go through that. But they may or may not recommend the person to file the case with IC. But definitely IC would recommend in some cases where we cannot have control. There's also a module coming up on jurisdiction later, so, not in this session, but on e-learning. So you'll find that where in that case, police would IC should sometimes recommend it to the law enforcement, namely police here, to take up the case and move forward, because the respondent may not be within the jurisdiction of IC. But police, I doubt if they will recommend them to file a complaint within IC, right? they may do that in some cases where go speak to your HR as well and see if they can file a complaint. So there's one more question in terms of, in some cases, if the respondent is out of the system, separated from the company, how can IC help the complainant to proceed with action on sexual harassment? So as I mentioned, if if they are not within your jurisdiction where IC can control or take any employment decision as per the service rule, because they're not in service, then it must be with the jurisdiction where, for example, if it is partner organization or client organization, during that conversation, if it happens, the complaint is going to the IC of that organization. And if it's in a public place like a restaurant or an airport, then the complaint should be filed with the, of course, even the restaurant owners or airport authorities may not be able to do much, so it must be dealt with by the law enforcement of that place, right? So IC should definitely help the aggrieved woman to go ahead and file that complaint, and whatever evidences are required, IC should voluntarily go and support them, because end of the day, the aggrieved woman should not be left um, defenseless, right? So whatever support that IC is supposed to provide, it has to provide that. Okay, I think I've overshot my time by more than 7 minutes, so I'll stop that. If there are still more questions, you can actually post that on the question panel, and I'll be more than happy to actually take it up. Thanks, Sandhya, for 354A. I know it's one of those, but thanks for that.